and the rest, they had to hold them for more than 24, 48 hours as required by law before presenting a suspect, charging them with an offense and presenting them in the court to have their own fair hearing. They had to go to the judge, this judge, Olatubosun, who eventually gave the DPP legal advice that they approached this judge that, yes, these people, it looks like we're going to be holding them for more than 24 hours because we are still investigating this case. They had to apply for a remand order that we want to remand this, we want to keep them with us for now. We need something to back us up because the law is saying we cannot keep them for more than 48 hours. So the judge granted them the remand application that, you know what, so you are going to keep them and continue your investigation. So it's now saying still the same before this judge that they presented these people back, that while you're waiting legal advice, keep these people. But then, as part of the internal rule of the police and their procedure too, they have the power to grant administrative bail too. Yes, the court has given them the power that keep these people in your hand. If those people, while doing the investigation, if they feel, okay, you can go home for that, but you have to report here every Monday, every Tuesday, the law has given the police that power to grant administrative bail. Because somebody might be asking, if the court is asking them to remand these people, how come these people got released somehow, somewhere? The police has that power to grant administrative bail to people in their custody. They just need some, oh yeah, bring your passport, bring this, bring that. That's what they need. So the second paragraph there is now saying that these investigators that we're talking about, the judge did not give them any instruction. That's the judge, they got the remand instruction from them. He didn't give them any instruction. The first respondent, which is Attorney General, did not give the police any instruction because the Attorney General has the power to give them instruction too. Or they now say even the investigator, that's the police, they are not under any law, any statutory duty that part of your investigation, no, you must go and inform the coroner presiding judge before forwarding your case file to the DPP. It is not part of their job. No law is compelling them to do that. And nobody has told them, you know what, this is what you need to do. Meaning that the police needs to go about their normal way of doing things. And their normal way of doing things is that after concluding their investigation, they forward their case file to the DPP for review and for legal advice. So it's now concluding that based on all this, the DPP and the police investigators and the Attorney General of the Federal of Lagos State, because they are working on a case based on the merit on its own, not really based on one deep inquiry or investigation, based on the merit on what they are seeing at first hand, that they are independent of the presiding judge, the presiding coroner. You can call them coroner, you can call them judge because they are judge before they are coroners too anyway. So that they are independent of that woman or the man, meaning they can do their own thing, they can run their own show while he or she is running her own show there. So the next paragraph, the respondents are answerable only to the presiding magistrate who ordered the remand pending the issuance and of whom the legal advice was forwarded when it was issued. That because of all this, Attorney General, DPP, even investigators, they are only responsible, only answerable to that judge who told them that, oh yeah, go and keep these people for now. That is the only person that can now tell them, let me see what you have done with this. Not the judge who doesn't know how the remand how it came about. So, the thrust of the intervention of the presiding coroner into the death of the late Ilerioluwa Oladimeji Aloba is different from the statutory duty of the respondent as pertain to the police case file. So they are saying that everybody gets their own duty. The coroner, in they do his own, he's doing his own. We have our own statutory obligation. What we need to do based on the facts we have, that these are two different things that should not be mixed up. While they're explaining that place again, while the presiding coroner's mandate is to determine who is the deceased, when the deceased died, where the deceased died, and how the deceased died. The mandate of the respondents, by now you should know who the respondents are, the Attorney General and the DPP. The mandate of the respondents, particularly the second respondent as the DPP, is to determine if there were any prima facie criminal inference disclosed against any of the suspects in the duplicate case file forwarded to them. Let's break that down now. So they're saying the job of the coroner inquest is to determine who died, the person will die, how he take die, when he take die, where he take die. That's who, when, where, and those are the four questions the coroner's inquest is supposed to answer. Who died, when the disease died, where did he die, and that outside that, the coroner's inquest will be acting ultra-vires. That, in contrast, the mandate, the job of the respondent, the Attorney General of the Federation, and especially the DPP, their own job is to determine if there's any merit, if there's anything they can infer, they can draw from the investigation from the case file forwarded to them by the police. So they are not supposed to go outside the case file forwarded to them. They are not the investigators. They are just there to prosecute based on the file forwarded to them. You see that they prosecute or they decline to prosecute that. You know what? I don't think we can get more evidence. Guys, go and get us more evidence, then we'll continue. Mhm. So, based on that, this man here is now trying to say, you know what, this is the job of this guy, this is our own job. So, the respondent vehemently denies paragraph 10, 11, 12, 13, 14, and 15 of the affidavit in support of the motion and states that the averment therein exists only in the realm of imagination of the applicant, and thereby put him to the strictest proof of the allegation. So I don't have the affidavit. I would have loved to read that too. So in the affidavit, you have it up to paragraph 15 or even more. So the respondent, that's Attorney General and DPP, they are now saying, no, we no go agree. Say waiting there for these paragraphs there. Say na lie. That everything where they talk for that paragraph, I don't know why we don't have that the affidavit. If Josie get mine, Josie, if you have the mind, release the affidavit. Let's see what you have there. Let's see the lies you've concocted there. So basically, you can from the words here vehemently, you know, say the lawyer no agree, the para say no, say which kind talk beyond this one. Say all these things where did this
Tapatapá
paragraph.
ṣe má bínú. Ṣé bó ṣe kọ́ lẹ́sẹ̀ edition?
Say all these things where this man talk for this paragraph, oh, say the man just dey imagine things. So say All these things can only exist in the realm of imagination. So you just sit down for us, you look silly. Say, I will say now maybe King of England. I will say that maybe president for one Obodo country. Say all these things can only exist when you have that quiet time in the toilet and you feel you are the owner of the whole world. So that's basically what this man is saying here. That and because of that, oh, they need to prove whatever they have said there. That if you decide that you can sit in the corner of your house and decide what happens in the rest of the world, then you need to bring some proof to all these allegations you have made because they've made a whole lot of allegations there. I know say they don't call Attorney General and the DPP, they don't call them different names. They don't abuse their mama, abuse their papa. Now why the lawyer vex like that? Say no. Say the only thing wey fit happen, you say this man just dey imagine. You don't want to tell am say whether the man dey mara or something. So, to the next paragraph. The respondent states further that neither the coroner nor the applicant have access to the criminal case file to ascertain and appreciate the legal basis that form the conclusion reached by the respondent in the legal advice. So they are now saying that I think they've said it somewhere in the earlier paragraphs that these people where they talk, they don't even get the case file for hand. So how they want to appreciate what we do? How they want to understand what they there? Though the corona magic, the corona judge, no contest here. They join the guy for the matter, say, may not two collect together. And then they give a number, then they throw one, give the woman there to say, and I not get case file for hand. You don't know waiting happen. You don't know waiting these people right there. What if the police say, they are based on our investigation, no? These people, we don't see them at all, no, they don't do anything at all. We don't see any facts say they do anything. So shame DPP because of that. Go say, no, they do something. No, they investigate. Do they have investigatory power? No, they have prosecutory power. They can only prosecute based on investigation done by the police. So they're saying these people don't get case file for hand. They hear the follow us argue say, "Na so this all matter supposed be." Say which kind of be this? That's what we have in that paragraph. They can't appreciate, they can't understand basically their own legal basis of saying or doing whatever they have done. So the applicant did not personally conduct any or engage private investigators who investigated and found incriminating evidence that establishes the culpability of any of the individuals discharged by the TPP's legal advice for the death of his son. So they don't owe Joseph Aloba for block us here now. Say, you not pay any private investigator. You not engage anyone. Maybe apart from Yomi. I think Joseph Aloba made a mistake here. If he had included Yomi in this one now, if you say, Yomi is my private investigator, so they say you didn't conduct any investigation of your own. You did not hire or engage any private investigator to investigate all these things you're saying, all these evidences you're coming here to say. You didn't get anybody to investigate for you, and you just come here, come the yarn of pata say, now one person kill your picking, now another person kill your picking. So they're just really telling that this man is irresponsible. This man just opens his mouth and things start coming out. That's basically what that paragraph is saying. So, upon a total legal review of the case filed by the second respondent, that's DPP, there was no fact disclosed that linked Mr. Abdulaziz Fashola, aka Naira Marley, Mr. Samson Balogun Eletu, aka Sam Larry, and Owodunni Ibrahim, aka Prime Boy, and Okpere Babatunde directly or remotely to the death, to and for the death of the deceased. They are now saying, case file will that no get, well now because of that they talk anyhow, yeah, me can't tell you now. Based on the case file with our own hand, we don't review am. We don't do holistic review to this case file. And in that case file, oh, any fact no dey there, we link these guys there, whether not directly or be remotely, or say na them cause the death or na them fight this boy. Say based on the case file we did their hand, say no fact they inside. So they are not saying there might not be facts later on. They are not saying this thing did happen. They're only saying based on what we have seen in the case file, there is not one single fact there linking these guys to this thing. What should we do? Should we just keep holding them forever? So moving on. The applicant and the other individuals who testified the inquest hearing into the death of the deceased did not provide any new, credible, and verifiable facts distinct from that, from what was stated in the case file forwarded by the police investigators to the second respondent, which directly or remotely linked Mr. Fashola, Naramali, all those guys to the death of the late Ilerioluwa Oladimeji Loba. So they are now saying, yes, even with the inquest where they go on, they hear waiting they go on there too, because they have their own representative in the hearing too. That up till now, nothing new where these people they talk. Because don't forget, all these people they wrote down their statements to the police. And anytime they come to the coroner's inquest to be interviewed or cross-examined, their lawyers will ask them, oh, do you remember this thing you've written down? Do you want to adopt it as your testimony here? All of them are saying yes, that is what they're saying. Meaning, that is what their facts are. And they are saying all these facts were in the case file. They are so waiting new where they can talk here. They not talk anything new. They not talk anything where they feel verify. Say even something where they new there. Say it is either it is not credible or they cannot verify those facts. So they are saying two things here that number one, nothing is new. And number two, the things new or whatever new they have said here is not credible. It's not verifiable. So what they're saying basically again to break it down further is that anybody saying that this one kill this one, that this one kill this one here in the coroner inquest, that person is either not credible or the person they lie. That is basically what that paragraph is saying. So, and I think this is last paragraph. Thank you for bearing with me. The applicants in these applications have not placed any material facts other than speculative statements and conjectures, such that could have faulted the second respondent's legal advice. And it is in the interest of justice to dismiss this application against the respondents. So it's now saying Joseph Aloba and his lawyer, they don't get any facts, any fact proof you say, this one fact or this one the main. Say the only thing where they get that speculation, say it be like say something can happen. It can't be like say after that one something can happen. That's all that's what they came with. They didn't come with any facts other than speculations, other than maybe it could be, it could have been. That's all they've been saying in the affidavit and in their case generally. That they didn't bring any fact to fault DPP's legal advice. Okay, now don't go collect legal advice. So see as na legal advice take wrong. This person will not release. See waiting, see the facts where they on ground. Read the video where we see the person, they kill person. Why not can't release am? Something like that. Something tangible. That in the interest of justice, because justice is not just about wasting people's time, wasting the taxpayers' money. Justice is about saving time when hearing cases, saving money for the taxpayers, and delivering justice. And in the interest of all this, I beg, make una try dismiss this application. And because, okay, no wala, then I come back on July 2nd. We will talk more about it and we'll see how to resolve this issue. So, Abomilele, you. Now, if
Welcome,
we
ẹ
have
káàbọ̀ sà.
questions, and we can now talk about it. Ekule Yami.
Ó wà pé tájọ́ rẹ̀ àwọn wá sókè jẹ́ ẹ̀kọ́ ó lọ jábọ́ lọ́wọ́ máa padà ní sábàtà góra bọ gbogbo nǹkan tẹ́ sọ yìí.
Yes,
Ṣé mo lè
Chabimi.
sọ̀rọ̀ ń sìn?
Tell me.
Nítorí mi mọ̀ bóyá fẹ́ sọ̀rọ̀ ní lẹ́yìn ìgbà tó pàtó tẹ̀. So
Yeah.
gbogbo nǹkan tẹ́ sọ ń sìn. Oh, okay, tájọ́ rẹ̀ ẹ go on, ẹ go on, ẹ go on.
So, good evening, everybody. I just have two questions. Thank you so much, Mr. Pythagoras.
Yes, ma.
So, the first question is, um, as a son, I feel like he should have done his due diligence before going to file that kind of motion, right? So I really don't understand why, because for me I think the charges has to be charges filed have to be appropriate. It's just like, for example, tí èèyàn bá unintentionally pa èèyàn, right? Unintentionally, you cannot charge that person as in pé it should be like, let's say, manslaughter and not that. But if the charges is not appropriately filed, there is tendency for that motion to be discarded, right?
Yes.
So in this case, I was just wondering, as a son, even like a junior lawyer shouldn't have made this. This kind. I mean, it's not a mistake. I think he was just trying to do his job, just trying to kind of thinking he's working. I mean, he's working for the money, just to justify the money, right? And the
Mm.
other question is, does the respondent, which is the DPP and the Attorney General in this case, do they have to record? Do they have to seek permission from the coroner inquest to make public their review or their judgment on the case, to see if the case can go forward or not? Do they always have to?
Yeah, sure. Uh, yes, number one, the lawyer, to be fair, as long as you decide to be someone's lawyer, you have to act in their best interest and based on their instructions. As
Based
long
on whose
as you want
instruction? Based on your client's
your
instruction?
clients, yeah. As long as you remain their lawyer.
Even though you know it is wrong or it's not going to be
No, if it is
admissible.
wrong in terms of law, except it is illegal. The only instruction you
Uh,
won't listen to from your client will be something against the law. To lie under oath, for example, to help them pervert justice, for example, knowingly. Those kind of things, you can say no to it and you can even report to your client to it for it. But anything other than that, it's either you stop being their lawyer or you dance to their tune. Really. That's just
Okay.
it's more complicated than that, but that's just a simple explanation. It's either you just
All right.
say, Baba, I know they do again, or you just continue doing their wish.
Oh,
Uh,
okay. Okay.
yeah. So it's but then if you practice to some extent, to some point, and uh your what's the word there now? Your image means so much to you, your integrity. You have that. There are some things that you stand your ground. You have the power to advise your client to convince them. And when you can do that, you have the option to say, you know what, I cannot do this in good conscience.
Oh,
But
okay.
then it's all about what you really want still. If I want money and somebody is telling me to come and kí wá lọ bá òun gba kí wá lọ bá òun sùn Charles pé òun ló yẹ kí tróònù kàn tó dẹ̀ jẹ́ pé ọmọ kí ló ti ń pè ọmọ ayédè ni níbì kan bá lọ máa sún ẹ̀ tó bá ti kówó ẹ̀ sílẹ̀ ń pé òun ni tróònù kan tó bá a máa fọ́ọ̀mù sítórì pé yes nígbà tí queen ni bóyá first àbí first queen ni wá ìgbà yẹn ni ó wá lóyún ẹ̀ Nàìjíríà bàbá ẹ̀dùn create a story conjecture báwa lọ́ba ṣe bọ́yẹn ń kó story jọ bọ́yẹn ń kó gbogbo assumptions àti conjectures jọ yìí a máa kójọ náà eventually tó bá jẹ́ pé ẹni tó ń wá owó tí ò kọ̀ láti ṣe anything láti wá owó of course they can do it within the ambit of the law even though it might be morally wrong they will still do it and they will still be doing their job still really they'll be doing their job. So for the second question, you're saying that yes, the DPP do not need their what's it called? Their permission. In fact, the DPP has the constitutional authority as per the law establishing them to either decide to continue to advise on whether or not to prosecute a case, to discontinue or not to discontinue a criminal proceeding. They have the authority. The Constitution grants them that authority. The 1999 Constitution grants them the authority to prosecute or to decide, you know what, we are not prosecuting, except where there is clear abuse of power. There's even a legal precedent backing it by the Supreme Court, stating that DPP cell, they get the power. If they say they won't do, they go do. If they say they don't do, nobody feel owe them. So that one is clear. And that is part of what these guys are trying to affirm here, that this might just they waste people time, that we have the power to decide if we want prosecute or not. Nobody can force us to do it. So I can tell you for a fact without preempting the sitting of the court, that no court can force the people, yeah, go prosecute. If they say they don't get fact to prosecute, say that the court won't go, oh yeah, make the court go prosecute now. So nobody can force them to do it. They
Okay.
have the authority, except where there is clear abuse of power.
Okay. Okay.
Yeah.
Okay. So the DPP determines the legality of any case brought before the.
Based on the facts presented to them by the investigating authorities.
Oh, okay. Okay. That makes sense.
Yeah.
Thank you so much. Appreciate it.
You're welcome, man. I'm sure pé visitor ti máa sùn lọ́n tiwọn.
wọ́n á ti sùn kánà ti sùn ni wọ́n á ti máa interject rẹ̀ ṣe ń sọ̀rọ̀
wọ́n ti máa
question
sọ̀rọ̀
mi
bẹ́ẹ̀
náà
ṣe ń sọ̀rọ̀ yẹn.
yeah question mi náà part of my question náà ni Tádérọ̀yà ti bẹ̀rẹ̀ lọ́ ti bẹ̀rẹ̀ yẹn pé ṣé Sanchito lè sọ fún Péjú sí nonsense ní kọ́tà fẹ́jọ fáwọn but hey he was hired, he was paid, so he has to do
Bẹ́ẹ̀ni,
his job. So
bẹ́ẹ̀ni.
I guess that is what
Tí ò bá ṣe kó
nǹkan
dówó
tó
lówó
ṣẹlẹ̀.
padà.
owó tí ìdí ti jẹ́. So I guess that is just what is there, because even with all this, I just think Sam should, be thinking about it like, hey, this is like a slap on his face. Hey, on a good day, this shouldn't be where if to find that. But hey, he has to die. And I think Josie is doing it for the purpose of mo try mo gbìyànjú láti wá justice for mi, ṣùgbọ́n fọ́ọ̀mù ẹ̀ dárí but it's so kìíní fóun. So I think that because Bayo was there ranting this morning about gbogbo jati and looking at it, even though èmi tí mi kì í ṣe lọ́ọ̀yà gan, it's so it's so clear right then. Pay, what is it that you are fighting for? You are fighting based on nonsense and rubbish. Ló ń
So,
jalè lórí. So,
kí tó continue,
ó yẹ go, ó
I
yẹ
just
go.
had to answer. Who was that again? Bonnie, Abina. Somebody was saying, yeah, princess. Yes, I was saying you should go check it out the other time. It's simple. Yeah, they might look confusing. Discharge is leave this guy, made it go. You don't have anything to hold him for now. I beg, let him go. Acquitted is that the case has been tried. We don't follow this guy, drag matter on top this crime. But we no see hand there. You are now acquitted. It is a final judgment. Acquittal is a final judgment. It's either that doesn't mean it can be appealed. For example, if an high court acquits you, somebody else can appeal that decision in the appeal court and even take it to Supreme Court, depending on the case. But for that court, for that level, acquittal is the final decision of the judge. It's a final judgment there. It means legally you have been cleared of the charges that was brought against you. It means you are not guilty after you have been tried. Means you have been tried, you have been tested, and you have not been found wanting. As opposed to discharge. Discharge is just more like a temporary stop. Like, you know what? We don't get anything to hold this guy, but we they carry one eye, they look at somehow. The person can still be arrested, they can still be tried. As soon as new evidence comes in, they can, hey, God don't catch you. We don't catch you for another one, so now you be this. So that is the major difference. But for the acquitter, it means for that crime, nobody can try you again. If you, even if now you do harm and you are acquitted of the crime, of the charges, otimu, may they go look for another charge, can't charge you. That one don't go be that. So, but in this case of these people, they were discharged, not acquitted. Meaning they were released because at the moment, as we stand now, there is no fact, there's no evidence to tie them to it. Should we stop them from their own lives? Yes. No. I mean, should we stop them from their own life? We cannot. Yes, we are. It looks somehow we are paying like, job and people you should go by. These are the things we know. But it's not about things you know. It's about the things you can prove in court.
It's about the facts and the
Yeah.
evidence that you can bring out from it.
Yeah, you have to prove it that yes, you might know A happened. How can you link A to whatever we're talking about here? How can you prove that A happened? Yes, but then you prove it. Ìbọn tó fi padà, màá ríbọn yẹn mọ́ o. Mo kàn dẹ̀ jọ pé mo ríbọn yẹn fìrí ni o. The case is going here. Case yẹn ń bọ́ lọ nìyẹn. Níbo ló ti rí tó ti pa? Èmi wà ní báńkólì ni, mo rí tó pa ń sàlẹ̀. Later on find out pé o jẹ́ èèyàn kan tó máa ń lògò o lògò láàárọ̀ ọjọ́ yẹn nígbà tó wà bá kó ní ẹ̀ wọ́n á jẹ́ kàn pé báwo lè rí nǹkan tó ṣẹlẹ̀ ń ta mẹ́ẹ̀ on a good day o máa ń lògò láti rí nǹkan dáadáa kéèsì tí ń
Wahala,
lọ
Mr.
down the drain
Batokas,
yẹn.
with what you said, there was a case like that, lóòótọ́, tí woman yẹn, that it was a murder case níbí báyìí ni, and kí lorúkọ ẹ̀ bíi neighbor yẹn kó wá sọ pé àwọn oríṣẹ́ òun rí nǹkan tó ṣẹlẹ̀ níjọ́ yẹn gangan, and they almost believe this woman until when somebody said pé obìnrin yìí máa ń lo oògùn And they now asked her, did you use your glasses? Only no, only but image tóun rí. So you saw an image, not that pé ẹni yẹn
Mm-hmm.
gangan ni.
Yeah.
So yeah, there was a
So you
case
have
like
to
that.
prove it,
Lóòótọ́.
otherwise, see,
Yeah,
why the burden of proof, especially for criminal issues on the high side, is because even if it's a 0.0009% that an innocent person might go to prison for something they didn't do, we have to prevent it. That's why the burden of proof is high when it comes to criminal issues. You have to really prove it that any ló ṣe kíní sẹ àwọn nǹkan tó dẹ̀ fi ṣe leléyìí. This is how it happen. Because tá bá leave ẹ̀ open bẹ́ẹ̀ yẹn tí wọ́n leave ẹ̀ relaxed, it's easy for ọlọ́pàá láti wà lazy about it that ìwèrè yẹn oníjàgídíjàgan ni ló máa pa bọ́ọ̀ yẹn jàre ó yẹ lọ tì mọ́lé. Ó kọ̀ dẹ̀ lè kọ̀ jẹ́ oníjàgídíjàgan kó má jẹ́ ẹni tó ń pààyàn. So èèyàn mélòó náà láti máa tì mọ́lé fún nǹkan tí wọ́n ṣe. That's why
true,
the
very
burden of
true.
proof is very important.
It's very sacrosanct. Yeah, yeah, totally so. Totally so. Then wọ́n ti question kan tí mo fẹ́ béèrè lọ́wọ́ nínú nǹkan gbọ́n. Wọ́n ti gbàgbé.